Answering the allegations of plaintiff's paragraphs 12a. Defendant affirms mishandling of client's funds, disappearance of $22,000. Defendant maintains that upon information and belief, the statements made on the absolute privilege documents are true and made without malice. The truth cannot be libelous and malicious. Plaintiffs are aware of the current active investigation in progress into bid rigging, mishandling and commingling of clients' funds and demanding payment without proper itemized invoices by the Supreme Court, Third Appellate Division, and Committee of Professional Standards as requested by defendant on the attorney complaint form. This libel claim is a bold attempt by a judge to publicly circumvent the due process of law and imprison defendant by filing this SLAPP, strategic lawsuit against public participation. Defendant is imprisoned when he is financially, emotionally, and physically unable to mount a defense mainly due to the fire and loss of everything. Plaintiffs, instead of helping, by doing their job as attorneys, act as responsible members of the bar and judiciary, and provide an explanation and records detailing the handling of the $22,000, choose to attack defendant and filed this SLAPP against defendant, their own client. However, it is plaintiff's burden to prove that statement in plaintiff's paragraph 12a is false, which they failed to prove. Plaintiffs produced no records detailing the transaction and handling of cash funds. However, there are greater charges and penalties to be applied here. Defendant respectfully requests that the court apply the maximum penalties to punish plaintiff's actions and conduct in filing this frivolous lawsuit and mishandling and commingling of clients' funds. On or about November 25, 2012, Grandview Palace Hoa put up for sale several Hoa-owned vehicles. The sale was advertised on Craigslist. The public was welcomed at the sale site but not the defendant. On the day of the sale, December 7, 2012, attorney John Theodore was present conducting the inspection and sale of the vehicles. Lawyer selling vehicles like a used car salesman. Upon information and belief, plaintiffs had the sale rigged to sell the vehicle to plaintiff John Theodore's father, Bob Theodore, for $9,000. Defendant showed up and got the price up to $20,000. The vehicles were finally sold for $22,000. Due to defendant exposure and outspokenness, the cash-strapped Hoa earned $13,000 more and stops the selling for $9,000 to plaintiff's father. Plaintiff John Theodore became very angry and shouted at defendant that he cannot be at the sale, because he did not pay his maintenance fees assessment of $90 per month. Defendant asserted his right to be present at a public sale and that others present do not have to pay an assessment to enter and bid on the sale. Plaintiff Theodore became even more furious and called the police. Defendant left the site. It was later discovered that Theodore had a secret deal to sell the vehicles to his father for $9,000, a clear conflict of interest, and certain unethical behavior on the part of attorneys. Upon information and belief, several appointment by a unit owner, Leonard Holden, made under New York Real Property, Article 9b, 339, W books of receipts and expenditures, availability for examination, to examine the books, especially the $22,000 and itemize invoices at plaintiff's establishment, failed. Plaintiffs refused to show the records, saying, "We have to make it up." Pursuant to Article X records and audits, this is clearly a violation of the bylaws and other professional conduct codes. Upon information and belief, it was later discovered that $22,000 was paid to plaintiffs in cash and check. A check in the sum of approximately $11,000 was deposited in the bank, but plaintiffs did not deposit the remaining cash of $11,000. Upon information and belief, plaintiffs pocketed cash in the sum of $600 and converted funds for their own use. Upon information and belief, plaintiff used some cash to pay the sign company. Plaintiffs failed to provide a full accounting of the vehicle sale funds of $22,000 after many requests. Plaintiffs failed to produce itemized invoices and records detailing the handling of HOA clients' funds. It is not normal accounting practice to deposit checks and keep the cash. The appearance of wrongdoing is worse than the actual act itself, more so, for members of the bar and judiciary. This whole transaction does not appear ethical, and instead of plaintiffs coming forward and provide records and explanation as required by law, plaintiffs chose to attack Facebook and one of the leaders by filing a frivolous libel lawsuit. It is not normal practice to pocket clients' funds and pay oneself with clients' cash. Defendant and others spoke up and defendant is slapped.